decision was irrational is because Dr. Hlophe's designation by the National Assembly coloured the entire decision as irrational. And here the present case, with respect, is analogous to what I mentioned earlier, the Similani case, the Democratic Alliance case. There the Constitutional Court upheld the Democratic Alliance's application to set aside the appointment of Mr. Similani as the National Director. The court, very importantly for our purposes, said this. It said that the President's decision to appoint Mr. Similani was irrational because the President had not considered clear evidence that Mr. Similani was dishonest and therefore not a fit and proper person as required for appointment to such an important constitutional position. And we reference this in our bundle of authorities. I commend you paragraph 89 of the Similani decision by the Constitutional Court. It's at case lines 45-686. Given the facts before the court and its knowledge that the President knew of these facts about Mr. Similani's dishonesty, the court said the following at that passage. It said the President's failure to consider such evidence was, and I quote, wholly inconsistent with the ends sought to be achieved, namely the appointment of a national director who is sufficiently conscientious and has enough credibility to do this important job effectively. The means employed accordingly colour the entire decision which falls to be set aside. The third reason we say that the National Assembly's decision was irrational is that it failed to properly understand that there in fact was a suitability requirement, an HSF paragraph 37 duty. My learned leader, Mr. Trengrove, has dealt with that. I shan't read to you again what was said in HSF by the Constitutional Court, but I would stress that when you reread it, you will notice that the Constitutional Court speaks about the responsibility, in other words, the duty on the persons who are going to be making this decision. They must discharge that duty seriously, and they must identify people who are suitably qualified for the position. And not just the ether, but bearing in mind in that passage the importance of the function, which is the critical place of judges in our democracy. And here, Justice Mbele.
Dr. Hlophe says that from the time there are allegations and throughout the process of him between that time and the time of his suspension, he's had so many. He has been part of the Judicial Service Commission and so many competent judicial officers appointed. What he says now is what is different from then, between then and now, that he will all of a sudden be a different person from what he was while awaiting the finalization process. I just want you to use clarification.
Sure. The simple answer, Justice, is that it's not what he subjectively believes. It's an objective question. So the objective question arises in at least three ways. The first is that the Judicial Conduct Tribunal, when it found that he was guilty of misconduct, gross misconduct, specifically said in its findings that it does so on an objective basis. Because the same arguments about subjectivity and how Dr. Hlophe in that case, or Judge Hlophe as it then was, had been raised by him there. And the tribunal said, no, it's not a subjective question, it's an objective question. That's the first answer. The second answer is that the question of whether the National Assembly got it right or wrong in this case, whether the designation was correct, is an objective question of law. It has to do with interpretation of Section 165.4 and the rationality standard we've mentioned. And then the third point, which goes back to the Zuma principle. It's not what Dr. Hlophe says are the reasons to justify what happened. The test is, what were the speaker's reasons? That's the objective question. What did the speaker say she understood by virtue of the discharge of her function? So it goes all ultimately to a question of law, not a question of feelings, not a question of subjectivity. And so what we see, and it perhaps leads to the next point, your question, Justice Mbele, is that the respondent's approach repeatedly is to insist that Section 178 of the Constitution does not expressly speak about somebody having to be fit and proper. That's their argument. They say, in other words, that there's no express suitability criteria that is posited. So the first answer to that, my learned leader, Mr. Trengrove, has given. It's the paragraph 37 HSF answer. But there's a further answer, and it comes again from the Similani case. We know that in Similani, the question was whether, under Section 179 of the Constitution, interestingly, the section that comes immediately after 178, both Section 178, which deals with the designation to the JSC, and Section 179, which deals with the appointment of a National Director of Public Prosecutions, neither of them stipulate that the persons have to be fit and proper. So there's no express requirement in either of them. But that very point was dealt with by the Constitutional Court in Similani, and I'm going to give you the reference. It's in Freedom Under Law's Bundle of Authorities at case line 45-632. And it's from paragraph 13b of the Similani judgment by the Constitutional Court. There, this is what the court said, and I commend the full passage to you. It says, Section 179 obliges national legislation to ensure that directors of public prosecutions are appropriately qualified. So it does that in respect of DPPs. But it doesn't say that in relation to the National Director of Public Prosecutions. No express requirement that that person must be fit and proper. And so says the Constitutional Court, there was some suggestion on the basis that Section 179 makes a continuous distinction between national directors and other directors, that the Constitution does not require the national director to be appropriately qualified. The argument we've heard here today, or will hear today, says the court, I'm prepared to accept that the reference to directors being appropriately qualified may be construed as a reference to directors of public prosecutions and not the national director. But here's the critical point. All this means is that the requirement that the national director must be appropriately qualified is not expressly stated in Section 179, just as it's not expressly stated in Section 178. But then, says Justice Jaku, this cannot mean that the Constitution does not require the national director to be appropriately qualified. That proposition, in my view, simply has to be stated to be rejected. The Constitution, by necessary implication, requires the national director to be appropriately qualified. So, on the basis of Similani as well, as paragraph 37 of HSF, the Speaker is with respect wrong to think that suitability was not a material requirement, and that there were only two requirements as suggested in the 9 July letter.
You have 8 minutes left, Mr. Requesting.
So let me then turn to the relevant and irrelevant considerations. Justice, what we see is that, again, the Similani decision is helpful. Because, and I'm going to give you the passage, it's case lines 45-656. Paragraph 52 of the judgment, the court said, these extracts from the report of the Ganawala Commission ought to have been cause for great concern. Indeed, these comments represented brightly flashing red lights, warning of impending danger to any person involved in the process of Mr. Similani's appointments to the position of National Director. And then critically, any failure to take into account these comments, or any decision to ignore them, and to proceed with Mr. Similani's appointment without more, would not be rationally related to the purpose of the power, and that is to appoint a person with sufficient conscientiousness and credibility. We commend that passage to the court because it is the entirety of our argument on the problem confronted by the National Assembly. The lights were flashing brightly red for the National Assembly. Its own debates on the transcript show that it knew that there was this problem of an impeached judge. But the National Assembly drove straight through. It never asked itself the question, what do we have to do about this? Do we have a rationality obligation to make sure that this is somebody that is not appointed ultimately or designated to the JSC? And do we do so in a manner which takes account of at least these three important things? First, that our courts have repeatedly spoken out about this type of conduct, namely that where a judge is impeached, it is because the charges against that judge are so serious as to destroy confidence in the judge's ability properly to perform the judicial function. Secondly, there is the Judicial Conduct Tribunal's own findings, and the fact that the National Assembly had endorsed those findings, and had just a few months previously decided that it was going to act and impeach. And so yes, the timing is important, Justice Ndaba. So we think that that is a factor that has to be taken into account. And then thirdly, there was the final bright red light that was again driven straight through by the National Assembly. And that is this. It's paragraph 69 of the Similani judgments, case lines 45-672. Said this. On the face of it, the contradictions reflect on Mr. Similani's credibility, integrity, and conscientiousness. They were and remain material. Any decision by any person aware of this evidence to ignore it in the decision-making process involving Mr. Similani's credibility would have been, on the face of it, and in the absence of an explanation from that person, not rationally related to the purpose for which that power was conferred. Justices, in my last 5 minutes, I want to turn to punitive costs, if I may. Freedom Under Law put up a supplementary affidavit on the 21st of October in the matter that was leading towards the leave to appeal judgment, and it set out 5 media publications. The court has seen those, and you've seen them referenced in the full court's decision in refusing leave. 4 quick points here. The first is there's no debate about the statements having been made, and that they relate to this court and to its judgment, and that they're made by MK, and that they quote Dr. Hlophe. Second, there's no debate that the publication of those statements is in direct conflict with their personal constitutional obligations. They are not any people, they are high officials of a party, and they are members of parliament in the form of Dr. Hlophe. Third, there's no debate about the shameful nature of those comments and their intended denigration of this court. You can read for yourself paragraph 22 of the judgment by Justice Wilson. I won't take you there in the time that's available. But fourth and finally, there's no debate about the statements that were made before this court, and they cannot be ignored. The defense that we've heard from our learned friends is to say that it's not fair to demand that we personally distance ourselves from an organization's statement. That's the argument. It's not fair, they say. This is in Dr. Hlophe's affidavit at case lines 39-10. This is not fair to demand that we personally distance ourselves from an organization's statement. But it is perfectly fair because of the Constitutional Court's judgment in the state capture case, referenced in our heads for full at paragraph 68, case lines 33-29. There, the Constitutional Court was also faced with such statements outside of the court, denigrating the court's judgment. And the court said this. It said, if the publication of these statements had no relation to him, in that case Mr. Zuma, he could have provided an explanation, either publicly or in these proceedings. He did not. He even had an additional opportunity to dispute his connection to these statements after the hearing of the matter. However, to date, he's made no attempt to distance himself from these statements. So it's a perfectly accurate invitation through the Constitutional Court's own judgment. And the Constitutional Court warned that it needed to do its duty in protecting itself from such statements in terms of Section 173, because such processes, or such statements rather, showed, and I'm quoting, President Zuma's disdain of this court and the judicial process, which carries the risk that he will inspire or incite others to similarly defy them. The second,
forgot to mention the case line reference number.
The case line reference is, it's cited in our heads of argument in case lines 33-29 of the Justice Indictment. Second and finally is the defense by our learned friends for the MK and for Dr. Zuma. They contend that they are entitled to exercise their constitutional right to freedom of expression. Well, the full answer to that, with great respect, is a judgment by His Lordship Mr. Justice Fabricius, which was cited in our heads for freedom under law, case lines 45-53, paragraph 153. It's the Moyane judgment. It's in our heads, case lines 45-53, paragraph 153. There are other relevant passages, and I close with this. He said, it is clear from my judgment that the conduct of the applicant in these proceedings is particularly reprehensible. It's vexatious and abusive. Both the office of the President and the third respondent have been attacked, insulted, and defamed without any reasonable cause. Allegations impugning their integrity and character have been made regardless of the objective facts, and insults have been hurled at every conceivable opportunity, with no reasonable or lawful grounds existing for such unwarranted attacks on the integrity of the first and third respondents. Then says Justice Fabricius this, in direct response to the argument that we have from our learned friends that they're just exercising their rights. He says this, not only is a cost order appropriate in this instance, but on the punitive scale of attorney and client for the reasons I've already mentioned, it's time that litigants realize that they cannot lightly make abusive allegations in court affidavits under the mantle of safeguarding their constitutional rights on the assumption that court cost orders would not be granted against them. In my opinion, on the facts of the matter before me, clearly shows that a punitive cost order was justified. His behaviour throughout the proceedings is abominable. We request punitive costs on that basis. Thank you, Justices, and I know my time is up.
Thanks, Dr. Peter, Mr. Duplessis.
Thank you, Justice Abela. I'm going to start my submissions by identifying 3 propositions which lie at the heart of the respondent's case. I will submit that each of these 3 propositions is inconsistent with the jurisprudence of the Constitutional Court and simply indefensible. And thereafter, I will address several further issues, mainly matters raised by the respondents, to the extent that I have time. The first foundation of the respondent's case that I want to address is this. The first foundation is that on their approach, a judge who has, for example, been impeached for taking a bribe. I'm not saying that Dr. Hlophe did. The premise of their case is that a judge who has been impeached for taking a bribe is a suitable person who is to decide who is fit and proper to be a judge. That person can be designated to the JSC. Similarly, a person who's been found to be a child molester is a suitable person to decide who is a fit and proper person to be a judge. And the reason I say that is that the respondent's case is that in relation to the opposition MPs, there are only 2 qualifications for appointment. One is they must be members of Parliament, and 2, they must be members of an opposition party. And they say that's all. Those are the only considerations that are relevant. They say that there is no test of suitability at all. So you can have the briber, you can have the child molester without any difficulty. They say there are only 2 criteria: membership of the National Assembly and membership of a opposition party. But I want to read to you what Justice Hlophe says in his heads of argument. If I can give you the case lines reference, it's at 46-50, and it's paragraph 73. This is what Dr. Hlophe says through his counsel. He says, Section 178 1H of the Constitution makes it clear that the majority has no veto or choice but to accept a nomination by an opposition party in the NA. The majority party may not usurp the power of the opposition party by voting for a candidate not nominated by the opposition parties themselves.
Can we get an indication?
It's 4650. He says, to do so would subvert the purpose of Section 178 1H and result in an unlawfully constituted JSC. He says, there is autonomy of political parties to choose from their members a person to serve in the JSC to be designated in terms of Section 178 1H of the Constitution. Well, we say that's simply not the law. That's not what the Constitution says. The Constitution says that the designation must be made by the National Assembly. And then if I can give a second reference, at 46-12, case lines 46-12, paragraph 5.11. This is what Dr. Hlophe says through his counsel. The NA process for designating members onto the JSC in terms of Section 170 are only required to ask 2 questions. That is of a membership of the National Assembly and whether the member belongs to the opposition political party. In other words, there is no requirement of the NA for the validity of this decision to have regard to the member's experience and qualifications. experience and qualifications are irrelevant, they say. That's their case. But of course that flies in the face of what was said in the Suitman Foundation paragraph 37, which you referred to already, that the task of the Assembly is to identify people who are suitably qualified for the position. So we say that it's not open to the respondents to contend that suitable qualifications are irrelevant to the decision to designate. The Constitutional Court has held otherwise in the clearest terms. They must identify people who are suitably qualified for the position. And that's what they do. To respond to the questions raised by Justice Mbele and Justice Basson, this of course doesn't apply only to Dr. Hlophe. It applies to anyone who is nominated. And it may be that their criticisms can be raised, that issues can be raised about the designation of other members. That's not an issue before this court at the moment. The only issue before this court is the designation of Dr. Hlophe. That's the case before the court, and we submit with respect that the court will deal with the case before it, and only the case before it. So on the respondent's case, the National Assembly could throw darts at a dartboard. People by throwing darts at the dartboard, as long as the names on it were all names of members of the Assembly who are opposition party members, because merit, qualifications, suitability doesn't come into it. You could just throw darts at a dartboard and say those are the people who are. That's not the way. This is an exercise of public power. Public power has to be exercised rationally. That's an element of legality. And you can't throw darts at a dartboard, and similarly, you can't ignore the suitability of the candidates. That would be equally arbitrary and irrational. That is what the NA did. The second foundation of the respondent's case is that if an opposition party nominates a person, the Assembly is obliged to designate them. That's the case advanced by Dr. Hlophe. I've read to the court what he said. He said this is part of their prerogative. That proposition is simply wrong. It's inconsistent with section 178 of 1H of the Constitution, and it's also inconsistent with the judgment of the Constitutional Court in the Helen Suzman Foundation case. The members of the NA, National Assembly, must identify people who are suitably qualified. I've quoted what Dr. Hlophe said. I've read that to the court. He is the leader of the MKP in the National Assembly. It seems that the MKP itself starts to distance itself from its heads of argument in this case from that proposition. But that's a matter for them to explain. Whose position is the right one? Is it the view of the leader of the National Assembly, leader of the party of the National Assembly, or is it Mr. Zuma? They can speak for themselves. The third foundation of the respondent's case is that the separation of powers doesn't allow the courts to rule on the lawfulness of what the National Assembly did. They say that the court cannot and will not rule on the lawfulness of what the National Assembly did when it designated members of the Judicial Service Commission. They say that the decision of the National Assembly is therefore effectively beyond the reach of the law. The law doesn't reach it. We say that is an astonishing proposition. In our constitutional democracy, the law governs all of the acts of organs of state. If the organ of state does not act lawfully, the courts must and will say so. They are obliged to say so with respect by section 1721A of the Constitution. There are no no-go areas in our public law where the law doesn't prevail. The law prevails throughout our public law. It governs all of the conduct of organs of state. It doesn't help to say, to squeak separation of powers. The answer to that is, was it legal? It wasn't legal. I wanted to quote what was said before the respondents lay so much stress on the position of Parliament, the special position of Parliament. wanted to quote what was said by Justice Davis for a full bench of this court in a case called Economic Freedom Fighters versus Chairperson of the Powers and Privileges Committee. This case reference is 2024, Part 10, BCLR, Butterworth's Constitutional Law Courts. 2024, Part 10, BCLR, page 1328. Decision of the Western Cape Court of Full Bench. And this is what Justice Davis said, paragraph 2. He quotes what Professor Mulvaney said in the famous article, and then he says, in this one paragraph.
Just one moment, please, because it's far ahead of some of us.
I'm sorry.
The page reference number.
1328. I'm sorry. I don't think it's in the Bible.
Oh, it's not in the Bible.
I don't think so. Pardon.
So, but one is another way of getting into that.
Yes, I'm told that it is. We can upload it if that would suit the court. Justice Madara, do you have it?
I'm trying to access it through
You won't find it on Twitter. It's only in Butterworth.
So I'm just here.
I think
Can I suggest that it must be uploaded?
it will be uploaded. This is what Justice Davis said, paragraph 2. He says, he refers to what was said by Professor Moranik, and he says, Professor Moranik captured the very essence of the legal principles on which our Constitution rested. The exercise of power is required to be justified by reason. Over the past 30 years of constitutional democracy, it is apparent that our jurisprudence has sought to indicate this idea not only insofar as the executive is concerned, but also in appropriate circumstances where Parliament exercise powers granted to it by the Constitution. So this principle of legality and reasoned argument applies both to Parliament and to the executive. It then refers to the fact, to the Mazibuko case, in which the Constitutional Court held a rule of the Assembly to be constitutionally invalid. The rules of the Assembly are subject to the discipline. Dr. Hlophe, in his Heads of Argument, treats the court to a lengthy exposition of the law in England with regard to questioning what happens in Parliament, questioning by courts of what Parliament has done. Somewhat ironic that we should turn to the position of the former colonial power, because under our Constitution, the courts are obliged to test and decide the lawfulness of laws passed by Parliament, the lawfulness of the rules of Parliament, and the lawfulness of the conduct of Parliament. All of those are things which the courts won't do in England, but we do it here all the time, because our law is different from the law in England. Our courts test, but frequently test, the validity of the laws passed by Parliament, the rules of Parliament, and the conduct of Parliament. And there is nothing in the separation of powers doctrine which prevents the courts from deciding whether Dr. Hlophe was lawfully and validly designated as a member of the JSC. That, with respect, is a core function of our courts. So then I turn to a number of 7 issues which are raised by the respondents. Yes. So let me just interrupt myself and say, those are the foundations of the case, of the respondent's case, that the National Assembly may not consider suitability wrong, that the National Assembly is bound by the decisions of the political parties, individual political parties, wrong, and that the conduct of the National Assembly is protected by the separation of powers, wrong. Then let me turn to some other issues. The first one want to raise his standing because there is a challenge raised to the standing of corruption. I submit with due respect that this is truly a defense of desperation. It is a defense without any foundation. Because in its founding affidavit, the Corruption Watch dealt with these matters. Could the court be invited to 0313? What the members of the court perceive that in paragraph 24, the Corruption Watch sets out the issues which arise in this case, which bear on its objectives and on its interests. Then in paragraph 25.1, the founding affidavit sets out why Corruption Watch can therefore bring this application in order to further its own interests. It's an own interest applicant. It's furthering its aims and objectives. Then in paragraph 25.2, Corruption Watch points out why it can also bring in this case, and does bring it in the public interest. Of course, the Part A court has already found that Corruption Watch has a locus standi to bring this application. It would be a very odd thing to find that it had locus standi on Part A and not on Part B. Then can I move to the second question, which is raised by my learned friends, and that is that, well, this was a decision of Parliament, and therefore it can't be challenged, we just don't like the outcome. We make the submission that when Parliament voted, it was not enacting legislation. We can debate what the precise pigeonhole in which to put its action. It might have been administrative action, it might have been executive action, it might be a special constitutional function. Not necessary to decide that. The one thing that is clear is that it was not legislative. It was exercising a special public power. And we know that the exercise of all public power is subject to review for legality and rationality. And so we say that it follows that the decision of the National Assembly, through a vote, is subject to review when it's, or at least when it's exercising these powers, and in fact even when it's legislative, is subject to review for legality and rationality. And the fact that the decision was made by a vote does not exclude the decision from review. We can all think of many examples of bodies which decide matters by a vote, and whose decisions are then brought under review. We think of the JSC itself. It decides matters by a vote, and its decisions are subject to review. We think of the decisions which are made by municipal councils. Their decisions are made by a vote, but they're subject to review. We think of the multiple boards and tribunals which sit in our country, which decide the matters by vote. Their decisions are subject to review. And so the fact that Parliament voted really takes the matter nowhere. It's important to be clear about what the National Assembly did. The members believed that they were bound by the practice of the convention, that they would designate and must designate whoever is nominated by the political parties. And I'm not going to repeat what the Chamber said in that regard. It's already noted fully that the National Assembly did not exercise the discretion which it had because it thought it didn't have a discretion. It was an error of the law, a failure to exercise its power. So what the National Assembly did was plainly invalid, and the separation of powers does nothing to protect it. And the fact that it was done by a vote does nothing to protect it. If it was unlawful and invalid, then the courts will set it aside. That brings me then to the third subject arising from the respondents' arguments, and that is a complaint of discriminatory treatment. The respondents complain that the applicants want the court to discriminate against Dr. Hlophe by holding him to the standard.
That's Section 9 of the Constitution?
Section 9 of the Constitution. There are two answers to this. First, yes, the court did treat Dr. Hlophe differently. I beg your pardon. The court in the Part A court did treat Dr. Hlophe in a particular way, and that was because of his particular conduct. He was a person who had been impeached as a judge, who had been found to have threatened and interfered with the independence, and impartiality and dignity and effectiveness of the Constitutional Court, who had been found to have threatened public confidence in the judicial system, and the person who had been found had improperly attempted to influence two judges of the court in favor of then President Zuma. That's what he was found to do. Fortunately, he is different from all the other members of the judiciary. So he is different, and he's treated differently. Nothing wrong with that. To succeed in an unfair discrimination case, it's not enough to show that you were treated differently. You must show that you were treated differently on one of the grounds in Section 9.3 of the Constitution. That you were treated differently because of race, gender, sex, marital status, ethnic origin, etc., etc. Dr. Hlophe doesn't try to make that case. He doesn't say I was discriminated against on any of those grounds. He makes no attempt to show that he was treated differently on any of the prohibited grounds. He doesn't even allege it, let alone provide any evidence. And so we make the submission that the complaint of unfair discrimination is simply without any foundation. It's a remarkable
What about 9.1?
Section 9.1. Equality before the law, yes. Everybody is equal before the law. It doesn't mean that
Isn't that what they're relying on?
I don't know what they're relying on, Justice.
Well, let's read the papers.
Well, they talk about discrimination. Discrimination is Section 9.3 and 9.4. The papers are peppered with complaints of discrimination. 9.1 is not triggered at all. It deals with a completely separate matter. It's equal protection of the law. But he has the protection of the law. He's here in court now defending himself against the law, defending against the complaints. He has protection of the law. It's a very remarkable thing to say, because a case is decided against me, I was denied equal protection of the law. The case is decided against you in American disabilities. There's no discrimination. So we say that Dr. Hlophe simply makes no case at all of unfair discrimination as defined in the Constitution. That brings me, Justices, to the fourth matter I want to address, arising from the arguments, and that is the question of a declaratory order. Why do we say a declaratory order is necessary or desirable? And as the court will know, we seek a declaration, or client seeks a declaration, that the National Assembly may not designate Dr. Hlophe to the JSC in terms of 178(1)H. We say this is necessary because of both the events leading up to the impeachment and the events which have taken place since this application was launched. Because since this application was launched, Dr. Hlophe has resigned from the Judicial Service Commission, and the MKP has stated that it will not withdraw his nomination, it will nominate him again. So we seek a declaratory order for two reasons. Firstly, because the MKP has made it clear that it will nominate him again. It will not replace him, it says. So you know that it's going to happen again. As a matter of certainty, because they've told you that they can be trusted in their word in this regard. Secondly,
would that now, if the court were to find that the National Assembly acted irrationally by designating him, should then now he be nominated by the MK again? Would that not give the National Assembly an opportunity to now exercise the discretion that they failed to exercise any? Should we, as a court, take away that from the National Assembly and tread in the terrain that does not necessarily belong to us?
I appreciate that proposition, Justice Mbele, and I say this in response. Firstly, we say that Dr. Hlophe has demonstrated by his conduct that he is not a suitable person to be appointed to the JSC. That doesn't change by going back and asking again. We say that his conduct demonstrates, and I'll come to that in a moment, his conduct demonstrates that he's not a suitable person. The second reason we say it is that Dr. Hlophe says that if he's appointed as a member of the JSC, he will vote, he will support the appointment of judges who acted like he did. He says, I want to, people like that should be appointed. He says, in other words, people who commit the conduct for which he was impeached. He says it's fine to go around and talk to other judges about the cases which are before them and try to persuade them to vote in a particular way. That's his case. We say that he's told you that he's going to do that. And we say it's impermissible to do that. And the JSC says already it's impermissible. And that's been upheld by the Assembly. And he says he will protect them against disciplinary processes when they do this. And he says, and he will presumably also protect them when he makes preposterous, with due respect, statements about our judges, which I'll come to in a moment, outrageous attacks on the judges, as he has done. He regards all of this as perfectly proper conduct for a judge. We say it's not proper conduct for a judge, and he is therefore not a suitable person. We say further that the appointment of Dr. Hlophe would make a mockery of the process of the JSC. Where in the world does one have a situation that someone is removed from the judiciary through impeachment for gross misconduct and then says, I want to be appointed to nominate my successor? He wanted to be a member of the JSC when it was going to nominate his successor as Judge President.
Why is Panzer still on the subject? It's an authority that, if I remember correctly, that fully referred to a judgment by House, which deals with this aspect of failing them to the decision made. I don't remember in the top one of my head what the decision is, but I seem to remember that was a referred to a decision by House, and I think the full relied on that, because that brings to life. What do you have to say to that?
Justice Mudau, it will have to go back to the decision maker. It will have to go back to the National Assembly. If the court finds that the appointment, the designation of Dr. Hlophe was invalid, there will be a vacancy in the JSC, and the National Assembly will have to decide to fill the vacancy. So it will automatically go back to that.
So we don't have to make a declaration.
All we say is when you do that, whatever you do, you can't redesignate Dr. Hlophe because he's demonstrated that he's unfit for the job. It's been demonstrated.
Is it our business to state that?
Well, it's the court's business to deal with what is an already promised repetition. The MKP says it's going to nominate him again. It will not withdraw his nomination. It will not replace him. Well, you know it's going to come. In that case, with respect, you don't close your eyes. Because otherwise, you'll be back here again in 6 months or a year, arguing the same case again and again in 3 months.
Additional Assembly 6 guidance, if I read them correctly, if we were to restate the law and the position in that regard in the process that they must embark upon, based on, say, paragraph 57 of the Helen Suitability Judgment, won't that be sufficient for purpose of this exercise?
No, because that's with respect, that's only part of why their conduct was unlawful. Their conduct was unlawful because they didn't do what the law required. They didn't follow paragraph 37. But their conduct was also unlawful because it was irrational. It was irrational and unreasonable to appoint to this fundamentally important position a person such as Dr. Hlophe, given the findings against him. And so we are saying that a declaratory order is necessary and is unrepentant about it. It would be different if he said, oh, I now see I made a mistake. I would never do it again. But he's unrepentant about it. He says he was entitled to that decision. And we say a declaratory order is necessary to avoid a repetition of the very conduct which lies at the heart of this issue, which led to the impeachment of Dr. Dr. Hlophe. We don't say that this is a case of a prohibition in perpetuity. Circumstances may change. For example, if Dr. Hlophe publicly said that he accepts that what he did is wrong, and he would not do it again, he'd be entitled to come back to court and say, well, now I'm a suitable person to be designated, because I'm no longer the person that I was when I committed this misconduct. But so we accept that circumstances may change, and therefore it would be permissible for if the court grants that declaratory order, it would be permissible for Dr. Hlophe to come back in due course and say, facts have not changed, please reconsider.
But now what happens with an order against the National Assembly that is
Well, yes.
in perpetuity?
Well, the simplest way to deal with it would be to make a more limited declaration. And if I could just find my note on this. Yes, the court could simply make a declaration that Dr. Hlophe is not a suitable person to be designated a member of the National Assembly. That's all. No declaration that he will never be a member. The declaration that he is not a suitable person to be designated a member of the National Assembly. That's not a finding of perpetuity, because circumstances may change and he can come back and say, I wasn't suitable and I am now suitable. So that's not a finding of perpetuity. And the court would make it clear in this judgment that this is not a finding for the ages. But as matters stand at the moment, Dr. Hlophe, having committed that misconduct and being unrepentant about it, is not a suitable person to be designated as a member of the JSC. Can I just say, my Leonard Jr. has passed me, I'd like to point out that in relation to the question of discrimination, Dr. Hlophe's heads of argument rely on section 9.1 for a claim of discrimination. It's a discrimination point he's making, and you will find that in his heads. I won't take the court there. It's case lines 46-15, not paragraph 6. The 9.1 claim is a discrimination claim. That's unfortunate. So for all of these reasons, we submit that it is necessary for the court to make a declaratory order that the National Assembly cannot reverse this process, this legal process, by simply designating him again on the advice of the MKP. Then, Justices, I come to a further point, perhaps it's the last one before the lunch adjournment, and that is that our learned friends have a lot to say about what they say are the collateral consequences of impeachment. He says when a judge is impeached, it has only one consequence, which is that he or she is no longer a judge. It doesn't have the collateral consequence that he or she is prohibited from being appointed, designated to the JSC. They're of course right in one sense. It's quite right that the Constitution does not say that a judge who's been impeached cannot be a member of the JSC. I think no one ever thought anyone would imagine that would be appropriate. But in any event, it's not there. But the point is, the issue is this. The Constitution requires the National Assembly to consider the suitability of the candidates. They must find a suitable candidate. And we say the conduct of a candidate. The conduct of a candidate is relevant to whether the candidate is suitable to be designated. And we say the conduct of a candidate, in this case, Dr. Hlophe's conduct, is relevant to two questions. Firstly, should he or she be impeached? But it's also relevant to a different question, which is whether he or she should be designated to the JSC. It's not the impeachment that makes him unsuitable for the JSC. It's his conduct as demonstrated by impeachment. And so it's therefore not his impeachment which renders him unsuitable. It is his conduct, which resulted in his impeachment, and also makes him unsuitable for designation of the JSC.
Is that splitting of hair? What led to his impeachment?
What led to his impeachment
was not the conduct complained of?
Yes. And his conduct has another consequence. It has a consequence that he shouldn't be appointed to the JSC. Not because he was impeached, but because of the conduct. The conduct has a direct consequence. One, impeachment, and two, it has a consequence in relation to the JSC. We say there's no question, as the respondents keep on assert repeatedly, that we seek to write into the Constitution a provision that an impeached judge may not be appointed. We don't seek that. What we say is that completely misstates our position. The position of Corruption Watch is that Dr. Hlophe's conduct, not his impeachment per se, makes him a person who cannot be suitable for designation of the JSC. Of course, it also may make him unsuitable for other things. If he was nominated to be the public protector, one might say, well, his conduct suggests he's not a suitable person to be designated for that. It may relate to all sorts of other things, and all sorts of other consequences. It's not a question of a collateral consequence of impeachment. It's a consequence of his conduct.
So in short, Mr. Ferdinand, what you are saying is the National Assembly, when it embarks on the process of designating members to the JSC, they must select amongst their members those that fit a certain criteria, which criteria will, in the process, enhance the public confidence in the judiciary, as you are saying.
With respect, exactly, Justice Miller, when the National Assembly designates from amongst its members, it will say, is this a person whose conduct leads us to be confident that he will add to the performance of the JSC and confidence in the judiciary? If his conduct is such that he's a person who members of the public will say, what? He's not choosing judges, and he's not a suitable person to be designated to the JSC. And it goes to the Helen Suzman Foundation paragraph 37. When you ask yourself, is a person a suitable person? What you look at is what he's done. And what he's done in this case is unfortunately inexcusable. And it would demean the JSC and would undermine the JSC in the performance of its functions. It's not a matter of trying to add an extra consequence of impeachment. It's simply that we simply say this, that no one who did what Dr. Hlophe did could be considered suitable for appointment as a member of the JSC. Justice Mbele, that may be a convenient time if you read the journey.
You still have 7 minutes, Mr. Ferdinand, but in that, if you are abandoning your argument at this point, the first part of your time allocation ends at 13:23.
Yes.
But if you want us to break now, and we will continue when we come back at 2 o'clock.
Yes.
We thank you for the 7 minutes that you're going to give.
Then I'll get my 15 minutes when we come back, my last 15 minutes.
You definitely will get your, not even last 15 minutes, 25 minutes actually, that's what we want. But
Thank you, Justice.
because you have been so gracious, thank you. Mr. Pope,
Thank you, my lady. I just thought, because Mr. Badlander still has the 7 minutes, maybe it's the right time. I didn't want to interrupt him. Just to make it clear so that he can address it now or in reply if he wants. But I don't know what Dr. Hlophe's case is on Section 9, just to address Judge Mdawi's question. But our position is that we rely on Section 9 as a whole.
9.1.
9.1 and 9, the equality clause, all of it. Yes. But I'll explain that when I'm out. But I'm just in fairness to Mr. Badlander so that he doesn't belabor on the basis that we also rely only on 9.1.
Thank you, Ms.
Escort, please.
Other gents, we shall reconvene at